Today is Saturday, May 6th. The future of the internet could be impacted by an upcoming Supreme Court decision. We're talking about a current case involving Section 230. That's the law that essentially lets social media platforms off the hook for what their users say online. But how could the Supreme Court's ruling change things? The man who literally wrote the book about it joins us to explain. But first, what does a squeaky dog toy and a Tennessee whiskey company have to do with the Supreme Court? We're talking about another case that's reached the highest court. This one is bizarre and a bit silly, but it's causing serious debate. The whiskey company Jack Daniel's filed a lawsuit against the toy company VIP Products. Luke Behnke will help break down the case and its potential impact. He's an attorney who specializes in business law, and he's the co-host of the podcast Litigation Nation. Welcome to the Newsworthy Special Edition Saturday, when we sit down with a different expert or celebrity every Saturday to talk about something in the news. Don't forget to tune in every Monday through Friday for our regular episodes, where we provide all the day's news in 10 minutes. I'm Erica Mandy. It's now time for today's Special Edition Saturday. Luke Behnke, thank you so much for coming on the Newsworthy.
Thanks, Erica. Happy to be here.
To start us off, what is Jack Daniel's reasoning for filing this lawsuit against the dog toy company called VIP Products?
So VIP Products has been selling its Bad Spaniels chew toy since 2014. It's part of its Silly Squeakers line of chew toys that mimic liquor, beer, wine, and soda bottles. They include Mountain Drool, which of course parodies Mountain Dew, and Heine Sniffin, among others, which parodies Heineken. And VIP also markets and sells a product that mimics a bottle of Jack Daniel's, which is a famous whiskey that's been made in Tennessee for almost 150 years. Now, instead of Jack Daniel's, the chew toy is called Bad Spaniels. And while Jack Daniel's bottles have the words Old Number 7 brand and Tennessee Sour Mash whiskey on the side, the toy proclaims the Old Number 2 on your Tennessee carpet. The original Jack Daniel's bottle also notes it is 40% alcohol by volume, whereas the parody chew toy features a dog's face and says it's 43% poo by volume, that's P-O-O, and 100% smelly. The packaging of the toy notes in small font that this product is not affiliated with the Jack Daniel distillery, but Jack Daniel's has argued in this case that the toy diminishes Jack Daniel's hard-earned goodwill by associating its product with excrement.
Okay, and so what is the VIP Products company saying?
So VIP is essentially arguing that the Bad Spaniels chew toy, like all chew toys in this line, is a parody, a joke that everyone knows is intended to be a joke. And perhaps the best illustration of each side's arguments came from questions that the justices themselves asked. So Justice Samuel Alito, who was appointed by President Bush, expressed skepticism for Jack Daniel's arguments in this case. He asked, quote, could any reasonable person think that Jack Daniel's had approved this use of the mark, close quote, which of course suggests the toy was an unmistakable parody and therefore legally acceptable. Justice Elena Kagan, who was appointed by President Obama and who's known for her sort of dry wit, suggested that the toy is simply, quote, an ordinary commercial product, close quote, that's trading on the look of the liquor company's bottle. In other words, a classic case of trademark infringement.
And just for anybody that doesn't know, parody is protected under the First Amendment. So is the question really, is this particular satire okay? Is it really about trademarks? Like, how do you explain what this is really about?
The district court, which is the lowest court at the federal level, found that VIP's use of Jack Daniel's trademarks to sell these, I guess, poop-themed dog toys was likely to confuse consumers. It infringed Jack Daniel's marks and it tarnished Jack Daniel's reputation. The Ninth Circuit, which is the appellate court, held that VIP's First Amendment interest, as you mentioned, in using Jack Daniel's trademarks as its own marks on a funny, and that's an important word here, on a funny dog toy, conferred special protection from the infringement claims.
And what are the potential precedents that could be set depending on which way the Supreme Court rules?
Now, some major companies have filed amicus curiae briefs in this case: Nike, Campbell Soup, Patagonia, Levi, among others. And those companies are urging the justices to side with Jack Daniel's. And of course, that makes sense, right? I mean, big companies want to have the ability to protect their trademark. There are several different angles to take here, but what the Biden administration is saying is, look, we hold these liquor companies to a higher standard to police their products. We don't want them advertising and marketing to a certain part of our population, namely, folks who are too young to make a good decision about whether or not to engage in an adult beverage. And so what the Biden administration is saying is, look, if we're going to expect these companies to police themselves, then we've got to give them a greater ability to protect their trademarks from trademark infringement.
And I think, overall, it's easy to poke fun at this case since it's, a chewy dog toy talking about going number 2. It doesn't really seem all that serious. But why do you think ultimately it did make it all the way to the Supreme Court? And how serious is it?
That's a great question. So it is a very silly case, but by virtue of the fact that it's in the Supreme Court, it's a very serious case. And I think the question is, why does the Supreme Court care? And I think the answer is twofold. Number one, it is a classic sort of trademark infringement case. And this idea of this likelihood of confusion analysis has been not well settled amongst the circuits over the past few decades. The second part, it involves an alcohol company that's arguing that it has to have a greater ability to police its trademarks than other companies.
So as you're watching this case unfold, any final thought or final takeaway for our audience?
I think the determination about whether, humorous use of another's trademark on a commercial product in a trademark infringement case is one that will be good. It'll settle an issue that has been out there for a while now. And it wouldn't be surprising if a decision was forthcoming in the next few months.
Still ahead, even if you haven't heard of Section 230 before, it's impacting how you're able to use online platforms. The law has essentially allowed the internet to grow into what it has become today because it protects digital companies like Google, Twitter, Facebook, and Instagram from being sued over what their users choose to post. But critics say once those companies start personalizing and changing what content each user sees, they should be held more accountable. Up next, I'm joined by an expert on Section 230. Jeff Kosseff is an associate professor at the United States Naval Academy and author of the book, The 26 Words That Created the Internet. He also has a new book you can pre-order now called Liar in a Crowded Theater, Freedom of Speech in a World of Misinformation. But first, a quick break for our sponsors. This episode is sponsored by BetterHelp. Reports have shown that burnout is on the rise. So if you've ever felt stretched too thin at work or at home or both, you're not alone. I know I have, and yet I think it's important to do something about it. Try to figure out why and learn new strategies to lower all that stress and exhaustion. Therapy can give you the tools to find more balance in your life, which is important not only for you, but also the people you love and want to support. I found that sometimes this meant saying no more often to unnecessary work things, or letting go of needing to do things a certain way at home, or getting more creative and intentional with my overall schedule. So if you're thinking of starting therapy to help you feel more like the best version of yourself, BetterHelp is an online-only, convenient option that matches you with a licensed therapist. You simply fill out a brief questionnaire to get started, and you can switch therapists anytime. Find more balance with BetterHelp. Visit betterhelp.com/newsworthy to get 10% off your first month. That's BetterHelp, HELP.com/newsworthy. And thanks to our other sponsor, CastleFlex. I'm sure you've heard of the benefits of stretching. So I'm here to tell you about a device that I found makes my stretching even more effective and its benefits more pronounced. Even after the first time I used the CastleFlex, I could tell a difference. And the more I use it, the better my whole body feels. My husband and I both have dealt with some back issues recently, so we've needed something to really work. The CastleFlex has helped so much. Think of this device as WD-40 for achy bones and tight muscles. And really, using the CastleFlex before you get hurt or deal with any issues is probably one of the best options. Plus, it's the same price as just 1 or 2 massages or chiro sessions, and yet it can be used daily for years. They even have a 2-week money-back guarantee. And now we have a code for our community to get a discount. So take advantage by going to castleflex.com. That's castle, like where a king lives, and flex, but with 2 X's. And be sure to use our code NEWS10 for 10% off. Again, that's 10% off with the code NEWS10, NEWS10 at castleflex.com. Okay, now to my conversation with Jeff Kosseff. Jeff Kosseff, thank you so much for coming on the Newsworthy.
Thanks so much for having me.
So first, can you just briefly explain what Section 230 is and what its original purpose was?
So what Section 230 is a law that Congress passed in 1996 that essentially says that the legal responsibility for content that users post rests with the users rather than the platforms where they post it. So if you were to go and defame me on Facebook, I would be able to sue you, but I would not be able to sue Facebook because of Section 230.
So the Supreme Court is looking at a case that may test the limits of Section 230. So I want to talk to you about both sides of this. First, can you briefly explain what the case is about and the family's reasoning for bringing the lawsuit in the first place?
Gonzalez v. Google involves the family of someone who was killed in the 2015 ISIS shootings in Paris. And it's a lawsuit against Google based on YouTube's carriage of ISIS content, so ISIS videos. And Section 230 would prohibit YouTube from being liable solely because it's carrying ISIS videos. So what the plaintiffs are doing is they're saying the liability is not based on just the contents of the videos. It's based on YouTube's personalization and targeting of the ISIS videos at users.
The algorithm behind YouTube contributed to this happening is what they're saying.
Exactly.
And so what's the defense for the tech companies?
Well, so what the tech companies first rely on is that Section 230 protects them from any sort of liability for third-party content. What they're also saying is that if you were to adopt the plaintiff's argument that any algorithmic presentation of content eliminates Section 230 protections, that this would discourage platforms from algorithmically presenting user content, which is something that has become really commonplace and everyone's grown to expect. And we don't want to go back to the early internet era where everything just comes up as it's posted, that there's actually very good reasons for platforms to use algorithms and personalization, and that there actually could be a lot more harmful content if you say that platforms need to stop personalizing content.
So if either the Supreme Court or Congress ends up narrowing the interpretation of Section 230, what could that look like for the average online user if tech companies then respond to a change like that?
So you might see fewer platforms. You're still going to have Facebook and Twitter and Instagram and YouTube, but a smaller or a mid-sized platform might say, we just can't take on the legal risk of all of this content because we don't have the budget. We don't have the legal budget. We don't have the budget for moderators that the large platforms do. You also might see platforms that are more likely to take down content when they receive a complaint. And now that could be good or bad because there are some people who complain to platforms about really harmful content that's posted about them and they don't get a response. But then you also think about how does a site like Glassdoor or Yelp survive? For Glassdoor, for example, if an employer doesn't like a review that an employee posted about them, they might complain to Glassdoor. But without Section 230, Glassdoor, I don't want to speak for them, but they might be more likely to take down that content. And you might say, well, what's the big deal about that? Well, if you have Glassdoor where employers are able to get all the negative reviews taken down, then I don't know how useful Glassdoor really is.
Okay, so give us an idea of, or at least a general idea of potential outcomes from this case. And what could various potential outcomes mean for tech companies?
So nobody's asking the Supreme Court to strike down Section 230, and there's really not a way that the Supreme Court could strike down Section 230. It would have to violate the Constitution, and nobody's making that claim. So there are a few ways that this case could come out. First, the Supreme Court could entirely take a pass on the Section 230 issue. The court could say that there's simply not a claim under the Anti-Terrorism Act, so we don't need to address Section 230 at all.
Which means Google is ultimately not held liable.
Exactly, yes. So Google wouldn't be held liable, and the courts that have been interpreting Section 230 broadly would be able to continue to do so. Now, the Supreme Court could say that after a certain amount of personalization of content or algorithmic targeting, that Section 230 doesn't apply. And the justices were really struggling with where they would draw the line there. So they seem to be somewhat sympathetic to the plaintiffs, and this is a terrible case. So it's understandable that they were, and they were trying to figure out, where would we draw this line where algorithms would suddenly mean that there's no Section 230 protection. And I did not hear any consensus view among the justices of where that line would be drawn. So that would be a tougher way to go. Justice Kagan said something along the lines of, we're not the 9 greatest experts on the internet. And what she was doing is suggesting that this is really a job for Congress.
Do you think it will lead to Congress doing something?
I think Congress really wants to do something about Section 230, but they're so stuck on these different visions of what they want the internet to look like that I don't see all that much bipartisan agreement on a way forward for Section 230 or for the internet.
What would be your final thought or takeaway for people to know as we go into this potential decision from the Supreme Court?
While Section 230 itself is not the same as the First Amendment, what it does is it creates a legal system that allows a platform to exist and carry the speech of millions or even billions of users. And I'm terrible at predicting how 9 very independent justices will rule on anything. But if I were to bet, I think the most likely outcome will be a punt on Section 230 altogether.
Thank you so much to both of our guests. Jeff Kosseff has a new book coming out later this year that you can pre-order now called Liar in a Crowded Theater, Freedom of Speech in a World of Misinformation. And be sure to check out Luke Behnke's podcast, Litigation Nation. We have links in our episode notes. And if you missed it, we talked about another major case before the Supreme Court. That one will decide the future of affirmative action. That episode aired on April 22nd and was titled Special Edition, The End of Affirmative Action. We'll let you know how the Supreme Court rules on all of these cases, as well as keep you updated on all the other news you need to know in our regular weekday episodes. We bring you our 10-minute news roundups every Monday through Friday with our signature fast, fair, fun style. We'll be back on Monday. Until then, have a great weekend.